Thanks very much for having me. That was a great introduction, thank you. And so you know who I am and who the EDO is from Felicity's presentation, so I think I'm just going to launch right in and have a chat about environmental justice. I'm going to start with some photos. I know they can be a bit rare at legal conferences. The photo on the slide is a photo of some protests that occurred in 1982 in a place called Warren County in Northern Carolina. It was a protest by the predominantly African-American community who were refusing or protesting against the construction of a hazardous waste landfill in their community. That's a photo from the aftermath of Hurricane Katrina, an example, I think, of natural disasters or natural environmental phenomena exacerbating the economic divide. It's a charming photo of military waste in Alaska. There's a large number of closed military facilities in the United States, and studies have shown that Native American people are statistically more likely to live near to these closed military facilities. It's a photo of air pollution in Los Angeles. There's been a study of ambient air toxic exposure and health risks on school children in Los Angeles, and those studies concluded that African American and Latino kids face a larger risk and high incidence of respiratory effects due to that pollution. A couple of photos there of some pygmy populations in Cameroon. They're the largest hunter-gatherer population in the world. And recently there was a pilot program that experimented, I suppose, with the transfer of the rights and responsibilities over forestry management from central authorities to these, the rights and responsibilities to these local pygmy populations. That's Harry Van Norst. He's a long-term client of the EDO Victoria. He's been fighting toxic waste dumps in Victoria for the last 20 or 30 years. A bit of a hero. That's Professor Henry Atkinson. He's a Yorta Yorta elder and the founder of Mildred, I can never remember this acronym, the Murray Indigenous Lower Darling Indigenous Association. So it's basically the coalition of Indigenous nations that live along the Murray-Darling Basin. And he basically led the Yorta Yorta people in a native title claim that was ultimately unsuccessful. And Henry is someone in that group who's still very determined to participate in natural resource management and for his people to do that. So, have you guys played with word clouds before? I just found this website the other day. My office manager referred me to it, and I found that it's actually really good if you're working on a document that you're really annoyed with or really frustrated with. You can generate a word cloud, and it makes you hate your document a little bit less, I think. So what is environmental justice? What are we talking about today? The EDO defines environmental justice, and so does the Environment Protection Authority in the US, as the fair treatment and meaningful involvement of all people, regardless of race, colour, national origin or income, with respect to the development, implementation and enforcement of environmental laws. So there's basically a distributive and a procedural element to environmental justice. So who gets what of the environmental harms and the environmental benefits in society, and who gets to participate in the decisions and the decision-making processes that result in that distribution. And so basically the EDO is interested in this concept. We think that or we know that in conditions of social and economic inequality, only some people obviously have the clout and the funding to get the powers that be to pay attention to whatever their particular concern is. And so, as I said, the EDO has become interested in this concept of environmental justice. We were successful in obtaining some funding to do some research into that, and I'm the lawyer lucky enough to be doing that project. So what I'll go through briefly in the presentation today is a little bit about how the environmental justice movement has evolved in the US over the last 20 years. Some cases that have been heard in the US, some environmental justice cases. A couple of examples of international applications of environmental justice, and then a quick discussion about how this concept is or could be applicable in Australia, and how it might be that an environmental justice movement gains some traction here. So the environmental justice kicked off in the United States essentially in 1982 with that protest in Warren County that I had on the slide. first up. And it was that population of African American people who said, we don't want that facility in our community and we're not having it. And not only that, we think that we've been targeted specifically by the government for the location of this facility because we're black, because we have low rates of education, because most of us don't vote, and because we have low political power in our community, and we're not having a bar of it, we're sick of it. And what happened after that was a number of similar protests in other areas of the south of the US relating to similar African American populations and similar facilities that were being imposed on them. And so soon after that, a study was conducted into the racial composition of these communities living near the 4 hazardous waste landfills in the south of the US. And the results were very conclusive. In all 4 cases, the people living around those sites were disproportionately African American. And so I guess a flood of research came after that into this concept of environmental justice and trying to show statistically it wasn't very hard that the people that lived around hazardous facilities of all types were generally of a disadvantaged community in some way, shape or form. In 1990, there was a conference in the US on this topic, and the results of that conference were sent to the EPA, the US EPA, who then were so compelled by the results and the discussions at that conference, they set up an Office of Environmental Equity, which was later called, renamed the Office of Environmental Justice. They then produced a report in 1992 named Environmental Equity, Reducing Risks for All Communities. And it was that report, I suppose, that acknowledged for the first time by a federal government that environmental inequalities did exist, which is something that has still not happened in Australia. And after that, in 1994, President Clinton passed an order that basically said that all decision makers, not just environmental decision makers, had to take into account the principles of environmental justice in their decisions, which is a pretty big deal, I suppose, at a federal level, and it really is exciting to think that in Australia, if we had a similar requirement about decision makers, what that would result in. So there's also been a number of environmental justice cases in the US, which is another exciting prospect if we could run something like that here in Australia. In 2001, a community in South Camden in New Jersey, went to court, the federal court, who subsequently suspended a permit for a cement factory because of basically the unfair impact that this plant would have on its neighbours. And the reason for this is that South Camden already housed the region's largest trash incinerator. They had a power plant, they had the county sewage treatment plant, and they also had a radioactive waste site. And the area also has one of the largest, the highest cancer rates in the nation. So the court said that the people who lived around the factory were just being made to bear way more than their fair share of the problems of pollution, and that they were being discriminated against because they didn't have a lot of political power and because of their race and their social economic demographic. And at the time, obviously, that was very much a landmark environmental justice decision. But then, there's always a but then, the Supreme Court decided another case and decided that people can really only enforce their civil rights if they can prove that the discrimination to them in locating a certain facility was intentional. So just saying that it had a discriminatory impact or a discriminatory effect wasn't sufficient. And obviously that's quite difficult. It's very hard to prove that there's been intentional discrimination on the part of a decision maker. It's very, very difficult to prove in court.